It's one of those classic stories you've heard before. One person going up against a big, powerful organization. But this time, it's not some corporate giant. It's about a regular homeowner and their homeowners association. And the whole fight was over something that sounds so simple, but is so incredibly important. The right to see the records.
So let's just start right at the end of this story, shall we? With this incredibly powerful and direct ruling from a judge. A homeowner won. The HOA lost, period. Okay, so how do we get here? Let's rewind and see exactly how a pretty straightforward request for some documents blew up into a full-on legal battle, with a final verdict that every single homeowner really needs to know about.
All right, here's how we're going to break this down. We'll start with the initial request. Then we'll look at the legal deadline the HOA totally missed, the new roadblock they tried to put up. We'll go inside the actual hearing, see the judge's final ruling, and then the most important part, why this matters to you.
So let's meet our main character, a homeowner named Jeremy Whittaker. On February 27, 2025, he did something that really should be totally normal. He sent a formal written request to his HOA, Vista Lakes, asking for a few records. And look, he wasn't just asking for random stuff. He wanted to see the brand new policy about how the HOA keeps its records. He asked for the minutes from the meeting where they talked about it, and he wanted to see the contracts with the HOA's lawyers. Basically, he just wanted to understand the new rules and see how the community's money was being spent on legal fees. Seems reasonable, right?
Now, this whole thing isn't just about common courtesy. Nope. There's a specific law that covers this exact situation, and believe me, it runs on a very, very strict clock.
And this is the absolute key to this whole thing right here in the Arizona Revised Statutes. The law is crystal clear. An HOA has 10, and that's 10 business days, to hand over the records a homeowner asks for. This 10-day clock is really the legal backbone of this entire case.
And this timeline, wow, it just lays it all out so perfectly. Whittaker sends his requests on February 27th. 10 business days tick by. The deadline is March 13th. That day comes and goes. Poof! Nothing from the HOA. Then, the very next day, March 14th, the HOA finally signs the brand new policy he'd asked to see. They officially blew past the legal deadline before their new rules were even technically on the books.
And I mean, let's be crystal clear here. By that March 13th deadline, it wasn't just that the documents hadn't arrived. There was nothing. No email, no phone call, no letter saying we're working on it, just complete radio silence.
So after the legal clock had already run out, the HOA finally pipes up. But they didn't show up with the documents. Instead, they showed up with a brand new obstacle. A whole new hoop for the homeowner to jump through.
Just look at this comparison. On the left, you have the law. All it requires is a simple written request. That's it. On the right, whoa, you've got the HOA's new mandatory form. It demanded a signature, it talked about buying copies, and it even required a deposit for big requests. They were literally just making up new rules that are nowhere to be found in the actual law.
So you might be wondering, what was the HOA's excuse for this? Well, their lawyer argued that the form was just to make things more specific when people wanted copies of records. But that's not the point, is it? The real question was, could they force him to use this form, especially when they had already broken the law by missing the deadline?
Well, you can probably guess what happened next. This whole mess lands in a formal administrative hearing. This is where both sides get to lay out all their arguments in front of a judge, who then has to decide who's right and who's wrong.
Okay, so here's the HOA's first big argument, coming from their general manager. She claimed that because the records policy and the meeting minutes weren't officially signed and finalized yet, they weren't technically official records. And because of that, she argued, they didn't have to provide them at all.
But Whittaker's comeback here was just brilliant. He pointed out the massive problem with that logic. He said, look, this board sometimes takes 6 months to approve minutes. If that's the rule, they could just never approve them. They could effectively hide everything that happens in their meetings forever. It would create this giant get-out-of-jail-free card for transparency.
And this right here is the heart of the HOA's entire defense. You got to hear this. Their lawyer basically argued that failing to respond isn't a violation. He said that if they think a record can be withheld, they don't even have to respond to the request. Their position was that just ignoring a homeowner is a legally acceptable answer.
So there you have it. Two sides, two totally different reads on the law.
One side says you absolutely have to respond in 10 days. The other says silence is a perfectly fine option. So what did the judge decide?
The judge's decision came down to one single powerful word: violation. The homeowner was right, the HOA was wrong.
And the judge's reasoning was just so direct. He said, the fact that Whittaker didn't use your new made-up form doesn't excuse you from, at the very least, responding. And then he dropped the hammer. No response by Vista was simply unacceptable.
So let's break down exactly how the judge dismantled the HOA's entire case point by point. He found a wrongfully withheld documents. He said their new form was not a valid excuse to just ignore the request. He made it clear that the burden was on the HOA to communicate. If they needed more info or if there's a cost for copies, it was their job to say so. They couldn't just say nothing.
But the ruling wasn't just a slap on the wrist. Oh no, it hit them in the wallet. First, the judge ordered the HOA to pay Whittaker back the $1,000 in filing fees he had to shell out just to get his case heard.
And you think that's it? Not even close. On top of that, the judge slapped the HOA with an additional $1,000 civil penalty. This wasn't just about paying the homeowner back, this was a punishment for breaking the law.
Okay, so a homeowner won and an HOA had to pay a couple grand. Big deal, right? Wrong. It's a huge deal. Because what happened here isn't just about one guy and his HOA. This ruling creates a clear roadmap for the rights of homeowners and the duties of HOAs everywhere.
So, if you're a homeowner, what do you need to remember from all this? Listen up, because this is important. First, that 10-day clock, it's not a suggestion, it's the law. Second, your HOA can't just ignore you. Silence is a violation. Third, they can't invent their own illegal barriers, like a special form, to keep you from seeing records. And finally, the responsibility to communicate is on them. It's their job to get back to you, not your job to chase them down.
And all of this really boils down to one final question you should probably be asking yourself. After seeing how this all played out and knowing exactly what the law says, how transparent is your HOA?